and I'll be your host today. Today we have Paula Gair here from deriskme. Now, we were enlightened last year a little bit about passwords and some cool tricks that we could use with that. What I love about having Paula on is that she makes everything so comprehensive and easy to understand. You know, when we talk about security, data, and privacy and the rules and how to follow them, it's great to have an actual educator in here who's good at communicating ideas and making it so that we don't glaze over and we get the insight we need to be able to make sure that our clients are safe. Their information is safe, our information is safe, and we're being respectful and complicit with the rules, right, Paula?
Yeah, absolutely. Absolutely.
Now, we do, just as a reminder, we do have some new folks that have been joining along to these chats. And so if you are new and you're streaming with us on one of our various platforms or here on Zoom, just a reminder that you can use the comment section, the chats function, or the Q&A function, depending on what platform you're streaming from, in order to engage with us here and get your questions answered by this expert, Paula. I'm looking forward to today's session, Paula, actually.
Yeah, great. Me too. I mean, I think that talking about things like privacy, it's usually a thing that people feel is a bit overwhelming. You need a lawyer. So we're just here to talk about it and make sure that it's really accessible for everybody.
Awesome. So I will let you kick off. Let's make sure that everything's working in the back and the share screen's working, and I will drive all the other platforms.
Fantastic.
All right.
Thanks for that warm welcome, Anna Murray. I'm really looking forward to this time with you this morning. I will answer questions as we go, and what I've put in my slides are lots of links so that you've got direct access to the relevant resources for you. So like I said, privacy feels like an area where people feel like it is overwhelming. You need to go to a lawyer. It's going to be legalese. And so most people and most small businesses just think, I'm just going to park that. And unfortunately, it means that most people's first kind of interaction with privacy is when something goes wrong. So what I'm hoping that we can do today is we can talk about how the Privacy Act works, and we're going to demystify what the principles are, so that hopefully at the end of the session today, everyone goes away with a bit of an idea of how those principles apply to their business. And then we're going to talk about a little bit about how to follow those rules, but also, what if something does go wrong? So we obviously want to hope for the best, but plan for the worst. So we're going to talk about that. And the Office of the Privacy Commissioner in New Zealand's website is an absolutely outstanding resource with every piece of information that you could possibly want written in plain English. And so there is no need for legal sort of knowledge or training to be able to understand things on that site. So I really would suggest that you go there, and a lot of the information I'm sharing with you comes directly from that site. So thanks to our awesome Privacy Commissioner. Okay, let's jump in. So New Zealand has a Privacy Act which is principles based. So what that means is it's not highly prescriptive, and it doesn't have a whole lot of things that it tells you you can do that and you can't do this in particular scenarios. What it does is it explains in very simple terms what the 13 principles are, and it's up to us in our businesses to make sure we apply those principles to everything that we do when we're capturing, storing, and using information. In addition to those principles, we also have some codes of practice. So there are particular areas like health information, for example, where the Privacy Commissioner has written additional detailed codes of practice. So if your business deals with data that falls under one of those areas, for example, in the health sphere, then familiarise yourself with those specific codes of practice as well. They also do offer and produce non-binding guidance. So when a particular issue hits the headlines or becomes significant to a large number of people, the Office of the Privacy Commissioner will often issue guidance notes. Their job is to make it easier for us to be able to follow the legislation and keep our customers and our businesses out of trouble, really. So an important thing to note, though, is in 2020 December, so just over a year ago now, our Privacy Act was updated. So if you were familiar with how things were prior to that, there have been a few changes. The most notable change is that in the past, there was no legal requirement to notify the Office of the Privacy Commissioner if there was a data breach. So, for example, if someone hacked into your computer system, into your CRM system, and was able to access personal details around your customers, as an example, there was no requirement for you to notify. Now, best practice would have said you'd let those customers know, but a lot of businesses didn't. The rules have now changed, and if there is a risk of serious harm, then you must notify, and there are penalties if you don't. The requirement to notify the Privacy Commissioner within 72 hours. However, as soon as you find out, and if you're not sure whether the threshold for serious harm has been met or not, get in touch with them. They will help you figure out whether or not it is a notifiable breach or not. So I've included a link in the slides to the reporting of the privacy breaches to the office from December 2020 through to the end of October 2021. And it's interesting because of the breaches that were notified to the office, only 33% of them were deemed to be to meet that threshold for serious harm. But what that means is a lot of organisations were doing the right thing, getting in touch and actually seeing whether or not the breach was something that needed to have some further action taken on. At the moment, so pre-legislation, there were only in the region of 10 to 20 breaches being notified every month. Now that legislation has passed, the number has gone from a low of 40 in January 21 to a high of 84 in June 2021, and the average is sitting around 70 notifications a month. So we're getting about 3 times as many notifications on average, and that number will increase as people get to know more about the legislation and the requirements that they have. So, I'm sure that you're all thinking, what is serious harm? So it's a pretty subjective thing. There is no absolute, there's no absolute definition of serious harm, but I want to give you the breakdown of the types of harms that were notified over the last, say, 10 months of the new Act. So the top one was actually emotional harm. So 35% of the notifications included emotional harm. And then going down in order, reputational harm, identity theft, financial harm, threats of harm, employment harm, loss of information, discriminatory harm, loss of opportunity, and at 3% physical harm. So it's important to note that what happens in the digital world can really cross over into the real world, and there is also a crossover between privacy and cybersecurity. So we'll touch on that a little bit towards the end of the session. The other thing that I found really interesting when I read this report is that the majority of the breaches occur as a result of human error. Maybe that's not surprising. We're all super busy dealing with so many different things at so many times, and the kinds of things that can happen are you accidentally send an email to the wrong person. A lot of the breaches that occurred are to do with health information. So there are examples where someone has sent an email and they've inadvertently included information about another patient's health conditions. So those things obviously can have really serious impacts for the person whose privacy has been breached. So 62% of the breaches was human error, 25% through malicious attack. So you will have all heard in the press last year around things like Waikato DHB, ransomware attacks. So obviously if data is exfiltrated, taken out from systems, then that is a malicious attack. There can be a theft of information, so it doesn't all have to happen digitally, actual physical information. Sometimes, some of the examples I can think about, I know that there was a judge or a lawyer who had case information that was printed out and lost that information. So again, that information should have been kept private and found its way into the public domain. And there can be faults in systems, that potentially publish information that shouldn't be made public and those sorts of things. But, interestingly for us, most of what happens is a result of human error, more than double the amount of the malicious activity. So it means if we put some good practices in place in our business, we can hopefully avoid falling into that same category. I thought you might also be interested to know which sectors are breaching privacy the most. Now, you have to take this with a bit of a grain of salt because, of course, it also relates to who knows they need to make these breach notifications. So at the moment, 54% of the breaches are being notified through the public sector. So that's not great. You know, government organisations breaching our privacy, but I would say that they also know they need to make these notifications. So the private sector is 35%, non-profits 11%. I would say that a lot of the private sector isn't yet aware of the requirement to make these breaches. So the numbers may not quite stack up like that in future. Interestingly, 79% of the breaches, 79% of the breaches came from healthcare and social assistance. So that's not great, right? Because it can be a lot of really sensitive information. And then in order from there, public administration, education, services, and finance and insurance. So, you know, it is happening across the board. So the other thing to just note is even though the requirement is to notify within 72 hours, only 44% of the breaches were notified in that time frame. So another 25% within 10 days, 15% in 30 days, and 9% with more than 30 days. So even if you find out later, or you think, oh, it's not such a big deal, or I don't think I've got a requirement to do something, or whatever it is, and you're outside of that 72 hours, I would really urge you to get in touch and have that conversation with the Office of the Privacy Commissioner, because they are really here to help. So yeah, that's there is a link to that in the slides, and it is quite interesting because it does give you a bit of a state of the nation of what's going on in terms of our breaches at the moment. So let's jump in and talk about how to follow the rules. And then I'm going to give you some tools and tips and some free resources as well. One thing to just sort of understand about this principles-based legislation is that, like so many areas of legislation, it's not completely black and white. So, for example, the serious harm definition is one area. And, you know, case law also informs these things going forward. So my advice to you is err on the side of caution. If you're not sure, get some additional advice, get in touch. And that's really the best, you know, that's the best way to keep your business safe. So a quick tour of the privacy principles. We have got 13 privacy principles in our Act, and they govern how you collect, handle, and use personal information, and that includes the storage of the information. So when you think about that, that literally means everything from the point where you might ask a potential customer for an email address through to the communications that you have with them, how you store the information, what you do with it in future. Okay, so we're actually going to go through the principles one by one, and that is because I want you to have a think about them as we go about how they apply to your business. And potentially, if you think, oh, okay, this might be a little bit of an area for me to look at, maybe make some notes for yourself to think about something that you need to go back and investigate further after the session today. So the principles are all written really, really clearly. There is more detail, obviously, on the Privacy Commissioner's website. But number one, really important, you can only collect personal information for a lawful purpose, and if the information is necessary for that purpose. So, you know, in the past, I've worked in marketing and comms, and one of the first things I learned a long time ago was try to capture everything I possibly can about a potential customer or a customer, because you never know what you might need later. So even if you're running an e-commerce business and you're, you know, only selling digital services and you never need to send anything by snail mail, capture the person's address. So that type of thing, or find out their date of birth because it might be useful for future customer segmentation, or these types of things. What I would say is that while you might be allowed to ask those questions, just think about whether or not you really do need that information. And if you capture it and you experience a breach, the more information you have, the more information that can be leaked. So the simple rule from my perspective is if you don't need it, don't capture it. And, you know, that means also if there is any kind of breach, then there's a lot less information to be removed from your system. The other thing to think about that from that perspective is that information goes out of date. So if you capture somebody's address and it was 5 years ago, the probability that those customers are all going to still live at that same address, if you haven't used the information in the meantime, goes down. So in fact, you're better off if you think I might need that at some future point, you capture the information when you need it. So the second principle is that we should be going directly to the person themselves to capture the information, right? So yes, it is possible to get information from third parties, but we shouldn't be doing that as a matter of course. If we can get the information directly, then that's what we should be doing. And you know, there are some examples where you can capture it from other parties. For example, if the person gives you permission to go to a third party, if getting the information in another way doesn't cause any disadvantage to that person, so maybe it is publicly available information, or the third one is a bit more complicated, but essentially if you would undermine the purpose of the data collection by going directly to the person. So, you know, when we think about our Privacy Act, it applies to all types of agencies that capture information for all sorts of purposes, including for legal situations. So, you know, it's not always possible to go directly to the individual in those types of situations. However, what we should also be doing is when we are starting to collect that personal information, taking whatever steps we can to explain, why are we asking this? Why do we need to know this information? Who is going to receive it? Is it optional or not? And what happens if they don't give you the information? So one of the things I think about is that if I try to sign up for an online account, I'm often asked for a whole lot of information that I don't think that organization really needs. And if it's set up in such a way that those fields have got a red asterisk, so it's a mandatory field, then there's no way for me to sign up for that service without giving that information. So often I'll make a decision that I actually don't want to interact with that service because, you know, I don't think that it's reasonable for them to ask that information. They don't need it for the purposes of our transactional interaction. So, you know, I would consider that type of situation one where you should consider, is it kind of compulsory for people to give you that information, or could you make it optional and voluntary? So this is really important, in particular when you think about more vulnerable people. So we've already talked about the fact it must be lawful. And obviously there's lots of other laws that intersect with our privacy legislation. They all apply together. But we want to not be unreasonably intrusive to people. And it's really important if you are dealing with children or young people, there's a higher bar in terms of thinking about the information that might be intrusive. So really consider carefully the type of information you're capturing from those people and whether or not you need, for example, parents' permission. So this is something we all need to be doing in our business, and this is where privacy and cybersecurity and security intersect really. Have you got the right safeguards in place to make sure that the information that you're capturing isn't lost, misused, or disclosed? So I thought one of the examples here that's quite interesting is it includes limits on employees browsing other people's information. So there have been examples where bank employees, for example, have looked up the bank accounts of their next door neighbours or friends or whatever. That is illegal. You're not allowed to do that. Most big organisations have got systems and processes in place, and that would be grounds for instant dismissal if someone broke those regulations and processes. But it's really worth thinking about in your business. Have you got those things in place as well? Also, just thinking about, oh, sorry, we've lost our slides here. Let's just resume back to our share. Right. And people also have a right to ask you for access to the information that you hold about them. So it's worth noting that, for example, in the past, there have been some cases where medical information and medical notes, where someone's been in hospital, has had some things written on the notes that are not necessarily medical. So they may be things that are discriminatory or in other ways offensive to the patient. And, you know, the patient has the right to see all of those notes, for example. So you really have to think, if you're recording something in your customer database in your notes, it's a possibility that your customer might see that information at some point. And, you know, you should always be thinking that that information could be viewed by the individual, even if the majority of people will never, ever ask you for that access. So if they do ask, you have to respond. There are a couple of exceptions where you don't have to, and some of these things are really obvious. For example, if you're going to endanger someone's safety, or there's going to be a possibility of harassment, then of course those types of things would not be examples where you would have to comply. And of course you can't breach a third party's privacy by complying with someone's request. So again, those things make a lot of sense, but you would have to have a good reason to refuse that level of access. And of course, if someone believes that the information that's held about them is incorrect, then they have the right to ask you to correct it. Now, if you don't agree, then you're not necessarily required to correct it, but you do need to still attach something to your database that explains what happened and explains what that person's point of view is. And then, you will have clarified why you're not going to update that information. So they do still have a voice, even if you don't have to correct something if it is not incorrect in your view, but you still do need to take some action there. And then before you use the information, you've got another step that you need to take. You need to check that it's accurate, that it's complete, that it's up to date, it's not misleading. So again, think about how often we capture information and we don't use it for a long period of time. And data can get corrupted on systems. Often data comes from multiple sources. There's all sorts of things that could happen. So, before you send something out, whether it's an email, whether it's snail mail, whether it's a phone call, it's really the responsibility is yours to take those reasonable steps. And you'll notice that in the law, there are a lot of instances where things are described as reasonable. That's a really tricky thing to define. And you hope that these things don't end up in court and people need to debate what's reasonable. But I think just take a common sense approach about under the circumstances, what would a reasonable person consider to be the types of checks that you would be expected to take. So we've also got, racing through here, we'll race back a bit. Right, we've also got one of the most important things, I really want us to think about this for a second. I think this is probably the area that the majority of organisations are getting spectacularly wrong. You must not keep personal information for longer than is necessary, right? So one of the shortest principles, but I think when you think about it in your business, if you've captured information in order to execute, a particular transaction or undertake one particular interaction with a customer, how long should you hold on to that personal information? So what would usually be deemed to be necessary would be to complete that transaction and of course meet any other legal obligations. So let's think about something like a real estate transaction. An example there may be that the real estate agent has to comply with anti-money laundering and know your customer legislation. So they've had to get personal information to satisfy those requirements. And they need to be able to prove to an auditor in that area that they have done those things. So there will be a requirement in that regard. And that type of sort of audit requirement should inform how long you need to keep that personal information. And remember, these principles all overlap. So again, if you are holding on to this personal information, you do need to make sure that you're keeping it safe and secure and all of those other earlier principles. Again, sounds obvious, but it doesn't always happen. You can only use personal information for the purpose you collected it. So for example, if someone undertakes an online transaction, maybe through e-commerce, through your business, and they give you their personal information in order to send the item that they've purchased, then generally speaking, that's all you can use that information for. You can't then go on and send them future offers for lots of other things. The best way to get permission for that is to give somebody an option to opt in to receive further marketing materials and information from you, and to clarify which channels. Do they want that by mail? Do they want it by email? Do they want it by SMS, etc.? So, it's not to say you can't ever market to that person again, But what you definitely couldn't do is then have a sister organization that was a different company selling a different set of products and just say, you can now start emailing this person. So you've really got to think about how close the purpose that you want to use the information is to what the original purpose was. And there are really only very limited circumstances when you can disclose information. So if that was the purpose, then you can disclose it. If the person concerned has authorized it, so often if you fill in, say, some kind of consumer credit agreement, you'll be asked to tick a box that says that you authorize the disclosure from other credit organizations. You know, in an insurance form that you'll often be asked to fill in, to tick a box that says you authorize the insurance company to get information about any other insurance claims you've made. So that's why they're asking you those things, because without your authorization, those disclosures aren't legal. One thing that is interesting is that with the increase in sort of big data and people using data in different ways, it is potentially possible for information to be shared if it's anonymous. So what you will see, for example, let's think about, say, reporting of COVID cases. There will be information that says there have been, you know, 10 new cases in Northland yesterday, for example, but that doesn't identify the individuals. And the reason that when the disclosures around cases are being made, and when talking about, for example, you know, if people have died as a result of COVID, that the information is only released when there's enough information that it wouldn't identify an individual. So, for example, you won't necessarily get individual information about every death. You might hear it after there have been 5. Sorry, not a particularly nice example, but you know, the whole idea of that is to protect the person's privacy, including after they have passed away. Now, disclosure is sometimes necessary to avoid endangering somebody. So in that case, that information can be shared. And of course, there are other laws that need to be met as well. But from a business perspective, it is really, really important that if someone comes to you and asks for information about one of your customers, that you're very, very clear whether or not you're allowed to actually give that information or not, or whether you'll be breaching the Privacy Act. Okay, we're nearly at the end of our principles. So there is an important principle if you're sending information overseas. So this is important because increasingly business is global, and maybe you have suppliers overseas, there's all sorts of things. So what has to happen is that the receiver is also either subject to the New Zealand Privacy Act, because they're also doing business here in New Zealand, or it's going to a country with comparable privacy safeguards. So I'm going to talk a little bit about GDPR, which applies in Europe. GDPR is even stronger than our privacy legislation. So, for example, it would be reasonable that the information would be kept under similar or in fact more stringent conditions in that market. And you do need to make sure that you have an agreement with that third party. So how you contract with them, and if this last piece is really important, if there aren't adequate protections, you can actually only give the information to an overseas party if you get express permission from the individual, or again, always those caveats about enforcing the law or health and safety. Okay, last one. This is really important increasingly as we store information in digital formats. So unique identifiers. So basically it could be a customer number, a customer ID. It could be any, you know, it could be in business, we have New Zealand business numbers, we have IRD numbers. There are all sorts of numbers that are unique identifiers. So it is deemed to be lawful that you only assign your own unique identifier where it's necessary for operational function. Okay, so if you have a customer database, it probably is necessary for your day-to-day operational function. But what you're not supposed to do is assign the same identifier as another organization. So for example, you wouldn't use the person's IRD number as your identifier, because what that then does, it makes it very easy for that information to be added to information from another source. And as you can imagine, there's a much bigger privacy risk if personal information is aggregated. And when you do assign a unique identifier, you must be really, really, really clear around avoiding issues and risk around misuse. So things like identity theft. So a lot to think about. This might be a good time to stop for any questions, if there's anything about any of those principles that anyone wanted to comment on. Got any questions for me, Anna Murray?
Hello. Sorry, I'm just busy floating from one channel to the next.
No
Lots of people
worries.
tuned in on Facebook, YouTube, and LinkedIn.
Great.
And there's no questions there as yet, but I have just instructed everyone, just drop your questions in the chat. There's a question here that says, is it okay to send marketing emails to customers who have given you their contact details in order to make a purchase, set up an account?
Yes. So you can, so the best practice is always to ask for an opt-in. But if you do send a marketing communication, it's absolutely essential that there's an opt-out, so that there is an unsubscribe. So every single one of your emails, even if your customer has given you permission, should have an unsubscribe link at the bottom. And you do need to make sure that if the customer uses that unsubscribe link, that you do follow that. Of course, if they make another purchase, you can still use the personal information you have to fulfill that purchase, but it is good to differentiate between marketing and fulfilling the transactions. What is best practice is when you send the email, you should have something in that email that says, this is why you're receiving the email. So in that case, you would say something like, you've previously made a purchase and we thought you might be interested in the following. You're welcome to unsubscribe from these emails at any time. And click on the link, and it's super easy for them to unsubscribe. One of my pet peeves is when you have to then log in to unsubscribe. That makes it really tricky. So ideally, it's just one of that you just make it as easy as possible for people. And it's good for people to understand why they're receiving the information in the email in the first place.
Yeah, fantastic. So, great question. And thank you for that. What a great answer. Just saying thank you. Fantastic. Let me jump over to the other platforms. Just make sure I'm not missing out on anyone here.
Sure.
To be good on there and here. And here. Yeah, they don't funnel through. So that's the only issue where I have to jump back and forth.
Just interrupt me at any point. That's fine. And I'll just crack on. So
yeah, go ahead.
Ideally for you all, think about what you need to do to follow the rules. So hopefully now those privacy principles are a little bit clearer. And so, you've already ticked this first box. You're starting to understand a little bit more of the legal requirements. And the next thing you need to do is create and follow a privacy policy for your business. And it's not really a set and forget. You do need to do regular checks to this. If you change things in the way that you do things in your business, then it is something to think about. Again, I am going to share a link to a tool where you can create a free privacy policy as well. So again, our wonderful Office of the Privacy Commissioner have developed a tool called Privomatic. The link is in the slides, and that allows you to go on and answer a series of questions, and then you get your own customized privacy policy at the end. And I really recommend that even if you've got a privacy policy already, it's quite a good exercise, because when you're answering these questions, it's making you think about how you both capture, store, use, the personal information that you're gathering. So it's a really, really useful exercise. The great thing is you'll have your own privacy policy. It should be at the bottom of all of your websites. It should be accessible to all of your customers. And then the next thing we're going to talk about is how to plan for a breach, how to respond, and then if we have any time at the end, we'll talk a little bit more about personal privacy too. So how do you plan? You need to have a privacy policy. We've just discussed that, and that privacy policy should address all of those principles. And again, best practice, try not to get it written by a lawyer in a way that ends up being 10 pages long and is almost impenetrable. Try to make sure that it's written in plain English and people can really understand what they're signing up for. And have a plan, so think about what you would do if there was a breach. So if you find out that either an employee has access data that they shouldn't, if someone's hacked into your system, if you've printed out some documents and you've left them on the bus, all of those things would constitute a breach, and you need to have a plan. So do a trial run in the business, figure out what your plan is, who do you contact, how do you do it? And the other layer of this is improving your own cybersecurity. So making sure that whoever has access to your digital systems is using secure passwords, ideally storing that information in a password manager, and definitely using a second factor of authentication. Not using shared passwords. Minimizing the access so that people only have access to do what they need to do for their job. And physical security is a thing too, right? So thinking about when someone comes into your office, can they directly pick up information that includes personal, and customer data? Like, do you have printouts of that sort of thing lying around? So, physical security is also definitely worth thinking about. Making sure that all the devices that access your cloud-based systems have got secure passwords and second factor authentication. So, if you lose a laptop or you lose a phone, that you're not enabling access to that information. So our the steps then, we want to go back. We want to talk about how we're going to plan. My screen's just frozen for a second. Okay, so we've talked about how we plan. What we need to then do is we need to respond if something goes wrong. And there are 4 steps to responding to a data breach. And what they are is, number 1, priority, contain it. What we don't want to do is make it any worse. So, for example, if you find that your website has inadvertently published information, so I'm thinking of an example of a charity that inadvertently they had a system that was supposed to deal with direct debit information for their supporters, and it inadvertently, it was a cloud-based system, it inadvertently got published to their main website. So it didn't contain bank information, but it did contain name, addresses, phone numbers, and email addresses. So number 1, get that contained, get that taken down. And then you need to do an assessment and figure out really what has happened and how serious is it. And this is where you start to think about the issues around serious harm. And it may not be obvious. You may not know how much the information has been shared. In the case of, say, hacking, it can be difficult to know how much access the hackers have had to your systems, how much information they've had access to. So you might need to work on a sort of scenario basis and say, look, this is the worst case. The good news is that you don't need to do that assessment piece on your own. Again, the Office of the Privacy Commissioner do have an online assessment tool, so it can step you through that process. So if you haven't done this before, if you step through, and again, at the bottom of the slides, all of these links to these sections are all there. Now, as soon as you think it's a serious breach, get in touch with the Office of the Privacy Commissioner. They have an online notification option, so you can do that, and they will help you with the next steps. One thing I would say, while in the past it wasn't a requirement to notify the office, and it wasn't a requirement to notify your customers, reputation is a really big thing. So what you need to think about is, if you don't notify your customers and they suffer additional harm as a result of that leaked information, and that then comes back to you, then your reputation and that customer's trust in your business really will have evaporated. So best practice is to let them know, and also think about what you can do to minimize the potential for harm. So I'm thinking of examples where people's financial information has been inadvertently shared. So what you may do in that case is you might offer a credit monitoring service to that customer for a year or 2 years or something like that, so they can keep track and just check whether there's any risk of identity theft. There's various things that you can do to try to mitigate the harm that may have been caused. And then probably the most important step of all is the prevention step. And the reason prevention comes at the end is that we know that things will go wrong. Unfortunately, there are sort of nefarious actors out there that are trying to do things that are, less than helpful to our businesses, as well as human error and sometimes, malicious things that can happen through our own staff. These types of things will happen. So what we need to do is make sure we learn from any of the mistakes that we've made along the way so we can prevent something else in future. You need to make sure that exactly what, how can you change your processes so the information doesn't get printed so it can't be left on the bus, or how can you increase your security so that your database isn't able to be hacked. These are the types of things that you'd be thinking about in a prevention. So this is how you respond, right? So again, Containing the information could be these types of things, trying to get the lost information back. So sometimes what will happen is somebody will find the information, realize it's personal information, contact you or the agency or whatever, and they'll return it. And you don't know, they haven't made a copy of it, but often they will indicate that they found it and they've returned it. And that should be a good indication that the situation has been contained. If the system has been breached and you're not able to fix it immediately, disable the system, until you know. So thinking about Waikato DHB, for example, with the ransomware attack, a lot of the systems for the DHB stayed offline for many weeks, because until they knew that it was 100% safe to put them back online, it was more of a risk. So that obviously causes massive inconvenience to patients and to staff, but it's more of a risk to put an insecure system back online. Obviously, if there's any breach that involves access, then changing access codes. So passwords and second factor authentication, but it could be physical access codes. It might be changing locks to offices. And, again, trying to do that, take that opportunity to look for any other weaknesses in your organization's physical or electronic security. So I've included the link here to how to notify if something has gone wrong. And there's a whole lot of great resources here that the website is very comprehensive. So I've tried to pick out the things that are most useful for you. If you're really interested in doing more online privacy training, you can do that. There's a free e-learning module available to you. The notify us in case of a breach, that's going to be an important link to for most of us. The other thing is this might get you thinking about your own privacy and wonder what organizations hold about you. To make it easy, then the privacy officer, has produced a tool so that you can request your own information. And this might be something that your customers do to you. So they might fill in this request and send it to you for their own information. So it's worth familiarizing yourself with that. I mentioned Privomatic. So that is a privacy statement generator. There's the link for that. And there's a couple of things if you are sending information overseas, some links that could be useful for you. In 2020, the office did a Privacy is Precious campaign, and there's some good resources there, including posters and brochures and things like that if you want to use those in your office. There's a simple 2-pager guide of the privacy principles if you want to familiarize yourself. And I mentioned that there are information resources around specific areas in terms of guidance. So that's the link to those information sheets there. And again, if you're thinking about yourself or thinking about your customers and how they might think about their own individual rights, then there's a good link there. So hopefully that means that you don't need to go through the whole website. That can just take you to the areas that you're most interested in. So where do you go to get help? So of course, hopefully by now, you're convinced that the Office of the Privacy Commissioner is going to be helpful for you, and don't see them as somebody who's got a big stick. They're basically there to help you. And then consumer.org.nz have a really good article on their website that explains basically what the Act covers and the various principles. So again, slightly different terminology, but exactly the same information, and it really does explain in very, very plain English. So that's a good thing to have a read of. It also gives you a little bit of information about the Privacy Commissioner and what their role is, and about mandatory data breach reporting. And most importantly, if you feel that something's gone wrong in terms of your own personal privacy, for example, it tells you what to do in terms of a complaints procedure. So it's a really simple and comprehensive resource. And basically, if you do want to know more, I recommend you read both of those sort of summaries, because they do explain the same thing in slightly different language. The last thing is actually an organization. It's actually a commercial organization, and it is data guidance across lots of different markets. So what they do is there's quite a good section on New Zealand data protection. So privacy is often called data protection in other markets. And it describes a summary of the New Zealand situation in the same sorts of language that it would use if it was looking at overseas. So again, that if you are a business that operates in more than one jurisdiction, you might find that helpful. So let's have a look at a couple of other tools that might be useful for you. And these are things that you can use for yourself personally. So if you are sick of being tracked around the internet and getting online advertising for something that you searched for once, then you can use a browser which is free to use called DuckDuckGo. It doesn't track you. So basically you can search for things and then you won't be, you won't be faced with ads for that thing forever and ever and ever. The other thing that I thought was worth mentioning is that it's really useful for us to think about our own personal privacy and security settings. And there's a couple of main places that you can look for this, depending on what you use yourself. If you use Google, a lot of people have G Suite accounts for their business. If you go to the myaccount.google.com area, you can check out your privacy and security settings and update those as you wish. And the keepitrealonline.govt.nz website has a lot of good information around specific apps, privacy and security settings. What I want to just sort of suggest to you is that the information, that when you set up an online account, often the defaults are super open because organizations like Google or Facebook or any of those services or platforms that basically trade in data want you to share as much as you possibly can. So there are settings to be able to restrict those things right down. And I would really suggest that for any of those social media accounts that you have, you do go in and you check your settings and you lock them down. The other thing that's really advisable is to try to separate your personal and your business. So, there are lots of people that are using personal Instagram accounts to promote their business. In an ideal world, you would separate those two things out. Same with Facebook, and if that's not possible, then go back in and strip out the personal information out of those social media accounts, because again, you also need to think about not just your customers and their privacy, but what could happen to you if you're targeted in some kind of privacy breach. So, thinking about that separation of business and personal as much as you can. And if you are concerned that you've got information out there and it's it's personal information, go in and strip it out. Because of course, for our social media for business, we want those things to be open to everybody because they're potential customers. But you don't want something like, your date of birth, for example, personal information on those sort of business focused platforms. So I thought it was just worth having a little chat about COVID-19. And I've included some links here for you as well. People have been asking me quite a bit about this recently. So there is a really detailed and clear privacy policy around contact tracing and also the use of the COVID-19 app. So the high level takeaways for now is that the information that you're storing is being stored on your phone. It's not going to the Ministry of Health. So if there is an issue, then the Ministry of Health will ask you via the app to share information with them. So, a lot of people say, oh my gosh, I don't want to share everywhere I've been with the government. Well, you're not doing that by using the contact tracing app. And this is also useful for you to know if you have customers that are asking you this. You've obviously, if you've got a physical site and you've got your QR code up, then it's useful for you to know when people are scanning it how that information is being stored. In order to develop something like the COVID Tracer app, it was necessary for the Ministry of Health to do a PIA, which is a privacy impact assessment. If you really want to get into the weeds of that, there's the details there. And there's also quite a good article. It's quite old now. It's from January 21, but it does explain and it does quote some cybersecurity experts that clearly explain how the app works and how the benefits outweigh the risks. So not necessarily strictly speaking what we're talking about today, but I'm getting a lot of questions about that, so I thought it was worth including. Quickly on the GDPR front, so General Data Protection Regulation is what GDPR stands for. It is the strongest data protection legislation in the world, and it's very detailed. It's much more prescriptive than our Privacy Act, and it covers things like lawful basis and transparency for data. So you'll see some commonalities there with our Privacy Act, where we're talking about only capturing information that's lawful. Data security is about how you store the information, and that is really, really critical. I lived in the UK for a long time, and it felt like at one stage every week you were hearing stories about health information being breached. So, someone had a laptop at the pub that didn't have a password on it, and the laptop got stolen, and it had 250,000 health records, and these types of things are just really appalling breaches. So, because of that sort of background, that's really why GDPR is as strong as it is. There are specific details in here around accountability and governance of the data and information, and around specific privacy rights. There's two things I wanted to raise that are not in our legislation, but I think they're really important to think about. And it's likely that over time our legislation will only become stronger. One of them is data protection by design and default. So what that means is that when you design a system, whether it is an e-commerce system, whether it's data capture on a website, whether it's a process to interact with customers in some other way, that you have to bake in the data protection, or in our case, we'd say privacy, through that design process. You don't try and retrofit it later because it's just never as strong. And also the default is private rather than the other way around. And again, the reason for this type of principle is because in the past, we've had a lot of organizations playing really fast and loose with our privacy and our personal information. Facebook is a good example. They have a terrible record with people's privacy. So this legislation has really aimed to tighten up those aspects. There's another principle, which is the right to be forgotten. So you can actually go to an organization and actually ask to be removed from their database altogether. As you can imagine, it's a complicated area. I'm not going to go into it in detail, but we don't have that here. But it is worth thinking about if a customer contacts you and says, I don't want to be contacted from you anymore, how are you going to do that? If you use external lists and things for marketing purposes, then you probably still need to have them flagged to be excluded. But if a customer really doesn't want to have anything to do with you any further, then best practice is absolutely to respect that and to follow up in that regard. If you are interested in the international side, here are some of the most useful resources. So the International Association of Privacy Professionals has been around since the year 2000. And it's the biggest international association of privacy professionals in the world. They've got amazing resources on their website about all manner of things, including some things that relate to New Zealand. There is a website on GDPR. It's pretty heavy going, I have to warn you, but there are some good guidance notes and these sorts of things. Now, the reason I'm bringing up GDPR is that if you have customers in Europe, GDPR applies to you, right? So if you are selling to a European customer and they're on your database, then there are some businesses that actually decide that it's too hard and it's too onerous to apply to meet those regulations, so they don't trade with European customers. So it's just something for you to think about if you have got those customers. Now, depending on the size of your business and what you do, there are different layers of compliance that are required. But if you have got European customers, you do need to look into what your obligations are. Right, so let's just think about your action list. Basically, please do visit the Privacy Commissioner's website, familiarise yourself, including all the information that's relevant for your business. So if there are guidance notes that relate to your business, definitely read those and become familiar with them. Review your privacy policy. First of all, it needs to be on your website. It needs to be accessible by your customers. Do use the programmatic tool if that's something that you think could be useful for you if you don't have a privacy policy in place. And make sure you understand what is in your policy. If it's been written by a lawyer, make sure you understand what it's telling your customers you'll do so that you're following those obligations. And think about how you're going to prevent a breach. What are the privacy risks in your business? What are the challenges that you think you could face? So again, we obviously plan, hope for the best, plan for the worst. And then really do plan to respond. So think about, familiarize yourself with what do I need to do to notify with a breach or to report a breach. Have all of the links handy. I mean, hopefully, if you hold on to the slides from today, then all of those links should be easy and accessible to you. But I would just say, as the number one takeaway, if you think that something's gone wrong, get in touch and do something about it. Don't hope nobody's going to notice. So good luck. So I hope that you'll use these resources to consider how the principles apply to your business and to put a plan together and be prepared to respond. But also do consider your own personal privacy and the privacy of your whānau, and take steps to protect this. You know, we do live in an increasingly digital world, and once information is out there, it's really, really difficult to get it back. So you may also want to set yourself another action after today, which is to go in and, you know, close down or restrict access to some of your social accounts, strip out your personal information. You know, if you don't show your birthday on Facebook, you won't get a happy birthday from everybody that you know, but it's much safer for that information, for example. It just is a simple type of data to not be out there. So I think we've just squeaked in under the hour, Anna Murray. I hope I haven't spoken for too long.
Never. We love it when you come on. You always give us such great insights into things. And also, I think the way that you run your sessions is not only detailed, but it's easy to understand, which I really love. Now, we had a question here, and I just wanted to make sure, because we delayed in asking it, whether or not the question still was valid. So the original question was, and I'm just going to pull it up. Can you give us more info about having a privacy offer in your business, and what do we need to get in place, qualifications, etc.? And then the follow-up was, I was under the impression that there had to be a privacy offer in every business. Great question.
So yeah, that is a great question. So when you think about it, if you are a small business, a lot of people are everything in their business, right? So the best thing for you to think about is, if you're running your own business, you don't have to have a third party who's a privacy officer. That can be you, but someone needs to be responsible for privacy in your business. But I would say that the best approach is not to take it from a compliance perspective and say, tick the box, we've got a privacy officer. It's more important that everybody working in your business understands the principles, because again, it's privacy, just like security, isn't really a set and forget. It's something that every time you make a decision about storing or using data, you need to be thinking about. So, you know, yes, absolutely, have a privacy officer, but don't think that then sort of ticks the box. It's very much about making sure that everyone who's dealing with customer data, whether it's, you know, and even things like if you're using a third party to design a leaflet or a data capture form or something like that, you know, you need to be thinking about that at that point, because that's where that opt-in tick box should be included. So, you know, everybody in your business and everybody outside of your business that's also inputting to how you capture information needs to be thinking about that. And, you know, that's also another thing that's really worth doing. If you are producing something, whether it's a data capture form on a website, something on paper, look at that, not just to make sure that the branding is right and it's been spell checked and grammar checked, but actually look at it from a privacy and security lens as well.
I think that's a really good point. And I also know that a lot of our folks that tune in with us here at Digital Boost are kind of one-man bands or, you know, mom and pop kind of shops, but thinking about that scalability and making sure that you're putting systems in place so that when you do scale, you are taking these considerations, these things into consideration is super important. And that's why I love having some of these sessions here, is because it is applicable to both people who are by themselves in their business currently, and it's applicable as you grow in a business. This is something that is just goes throughout every business, you know, and it's something that maybe we don't find as the party, but we need to pay attention to, and we need to make sure that these systems are in place to protect the data of our customers and our own stuff.
And our own. Yeah. And I think that the other thing to think about is there's a potential for a competitive advantage in this field. So for example, customers, consumers are becoming more conscious of privacy as we all hear more about breaches and this sort of thing. So you can actually make this a point of difference, right? That the fact that you are really, really onto it in terms of your customers' data, both in terms of what you capture, how you store it. So if you tell people what you're doing to keep their data safe and how you use it, that may well give you a competitive advantage over somebody else who's got a much more, let's say, relaxed approach.
Excellent. Totally. Absolutely. I mean, we could use any advantage that we can get. And I know that you talked a little bit about that accessibility and all that, the ability for people to be able to unsubscribe or to not do those things. And we're going to go into accessibility even further, talking about folks that 20% of New Zealanders could use more tools on people's websites to be able to access those websites. And we're going to move into accessibility a lot this year. I think it's really important, and I have a real passion for it, as well as the privacy of people's data and information. I think it's super important, and we need to put a lens on it here at Digital Boost. So I just want to thank you again, Paula, for joining us here today. I always love getting to touch base with you, even in our little 10 minutes before the session, but I always get such great information out of your sessions. You're an amazing educator, and we're really honored to have you come on and join us.
Thanks so much, Anna Marie. It's my pleasure to join you. And I will just pop a couple more links in based on some of the questions that have come up today, and then the slides will be ready to share later on today.
Yeah, that's a good point. So these slides, Paula will pass them on to the team, and we will upload them onto the site. So if you're one of the cheeky folks that tunes in with us on our social media channels, but hasn't registered to digitalboost.co.nz, get yourself registered, because you're missing out on competitions and provider offers, but you're also missing out on the slides that we pop up underneath most of our sessions as PDFs, as additional resources for you to use. So you don't have to rewatch the whole session. You can just download the PDF and find the information that you were really looking for, or you weren't able to take a note of quickly enough during the session, and get access to that right away. So do sign up, digitalboost.co.nz. And if you need any help, contact us at support@digitalboost.co.nz. We're here to help you. And I know that Paula, did you put your contact details up there somewhere? I know you can.
They will be at the end of the slides. Yeah.
Yeah, fantastic. Thanks again for saying thank you to our presenter. Everyone have a wonderful day, and I will see you tomorrow. Ka kite.